Welcome back to Slop So Bad You Wouldn't Even Give It to the Dog. I've been waiting to talk about the person today, one of Hassan's orbiters, and yes, I know about that weird fucking fanfic puff piece he just did, and I couldn't even read that bullshit, let alone let you guys see it.
Next to Piker, as he pants in a pair of neon shorts with black Calvin Klein. What the fuck is this? What is this?
Today we're going to be talking about denims and the lawsuit she is in with Ethan Klein over her breaking the copyright laws, and she is demanding for a trial by jury. Now, I really don't understand why her defense team would think this is a smart idea. Not only is the evidence out there because, you know, she streamed it, but I'm sure they could comb through many of her clips and find her just talking poorly about Ethan, which they could probably use as evidence that with ill intent she broke the copyright law and for sure was trying to take money from the original creator.
Well, guys, if you enjoyed not giving any views to that terrible video, follow, subscribe, throw a prime.
I guess in a way though, I could also see people on the jury wouldn't even really understand the situation, so maybe they're hoping for something like that. They'd just be like, oh, she didn't know or something, but I doubt it anyway. Anyway though, she responded to the lawsuit with 18 separate affirmative defense. Here's a video of a lawyer, LUS, breaking it down.
Defendant lacks sufficient knowledge or information to form a belief concerning the truth of the factual allegations contained therein, and on the basis. So you can look at number 11 and it's copied and pasted, copy and pasted. There are basically two boilerplate responses. She has a total of 18 defenses. Yes, 18 affirmative defenses. And with the 18th being reservation for additional defenses. So she has 18 reasons why she didn't commit copyright infringement. And these are going to vary from really good, like almost like okay reasons, to just really bizarre. And like I said, when you first respond to something, you want to keep all your options open. You kind of just throw everything at the wall. If something sticks, that's good. If something doesn't stick with the judge, that is bad, right? That 18 defenses. Typically, you don't want to have that many. Typically, you want to just focus on the strong ones. And because now it seems like you're losing when you lose a defense.
Yeah, it's already looking bad if you gotta hope anything will stick, and really it just sounds like she's using the defense of, well, I didn't know, which obviously does not work. Even so, it really seems still like she just thinks she isn't guilty or did anything wrong, which, I mean, she's probably never had to be accountable for literally anything in her life or much at all. I mean, I definitely think these streamers just feel safe because it's the internet and they're in their comfy houses and all that fucking bullshit, but they forget that the internet shit can translate into real life shit. And like I said earlier, it's 18 separate affirmative defense, which I'll throw up a picture of what it legally means, but essentially it just means that even though I did something wrong, there's a legal reason why I shouldn't be held responsible. Yeah. What does that say about her defense so far? I mean, this is just hilarious anyway. Here's some more from the lawyer.
Failure to state a claim. So this one is, A, you can't sue me because why you didn't tell me what you're suing me over. Again, just kind of throw against the wall and see if it sticks. This one would obviously be the best way to do it because then the case would just go away. Second affirmative defense, fair use doctrine. So she is claiming fair use, which correctly predicted. This is the obvious one that, hey, you know, I did enough commentary. It was transformative enough. There are 4 pillars of fair use, and we have gone over that. And whether or not her playing the video was fair use, I disagree with. Third affirmative defense, express license, the complaint in each, which means that the plaintiff granted an express license. So, hey, you can play my video, or you can use my copyrighted material, you can react to it. Ethan Klein, that's what she's saying Ethan Klein has given her. The fourth, implied license, where expressed is you specifically say, I'm giving you the ability to play my copyright material. Implied is implied.
I mean, she's dumb as hell. They have to make any kind of excuse because there's literally a video of her saying she's glad she took the views and glad to take his money and did take money away from the original creator. Like, come on, brother. I feel bad for Ethan's legal team, or maybe not. Maybe they're the ones getting the real bag. Here's some more on the other stuff.
Fifth, unclean hands. Plaintiff's claims are barred in whole or in part by equitable doctrine of unclean hands. This is a very unique take. I don't think it's going to work, but Unclean Hands is, hey, this guy has taken some of my stuff and then now I'm taking some of his stuff and he was taking some of Hassan's stuff. And then, so.
Now, I'm not gonna lie, that's kind of funny, but definitely not the same. I mean, I thought courts were supposed to be professional, but this is like what a kid would say. Oh, well, he touched my stuff or he did it first. Like, come on, we're seriously wasting people's time. Anyway, here's a little more.
6, affirmative defense waiver. The complaint in every action set forth is barred in whole, apart in the doctrine of waiver. That one doesn't make sense to me. Estoppel is barred in whole by the doctrine of estoppel. At this point in time, they're just throwing stuff at the wall, and a lot of this is not nonsensical in my personal opinion, but they just need one. I mean, who knows? So here we have justification and excuse. That any of defendant's actions taken with respect to plaintiff was justified and excused. What's the excuse? What's the justification? I guess we will find out later in court. Maybe it's like, hey, I have to make this video about Ethan because I had to get my opinion out there, and Ethan was a bad guy and all this stuff. So again, this idea of unclean hands, right?
As you can see, Denham's lawyers are trying so hard. I mean, really all her arguments are void because Ethan got that video registered, and I mean, through a lot of these affirmative defenses, it's like half their defense is, well, we didn't know, and the other half is, well, he did it first. They can't even keep to one defense. Let's watch some more. Apparently it gets more weird.
So consent, this is very similar to the implied versus the express license. Ethan gave his consent. Actually, it says expressly implied consented. So they're kind of double dipping here. This is actually very similar to 2 of the other ones. Innocent infringement. So this is mitigation. So you can say, hey, I infringed, but I did so unknowingly, and I didn't know this was registered. And, hey, I get it. I infringed, but I don't want to. So part of this is mitigation, no injuries or damages. But this is really interesting because statutory, this is the whole reason that Ethan had to go register this, is because very hard to prove injury or damages. This would be great if the thing wasn't actually registered, but okay. Again, there's 18 affirmative defense. So instead of focusing on 2 or 3 of your best ones, they've decided that, we're going to do everything. Inequitable conduct, the complaint, and as it goes down the list, it's getting like more and more bizarre. The complaint in each action therein is barred in a whole or part in damages limited to defendant as a result of plaintiff's inequitable conduct. Basically, it's saying Ethan is an asshole. Because he's an asshole, we can steal unjust enrichment. Plaintiff will be unjustly enriched if allowed to recover to the extent as alleged. So there is something that people are not talking about on Ethan's side. It is, you have to prove that they knowingly did this. And the damages can be dependent, even if it's statutory, even if it is registered copyright, which it is. Judges and juries can give various amounts depending on mitigation. So even if you're guilty, so I'm not guilty, but if I am guilty, I don't deserve to pay Ethan $150,000 because I didn't do that much to him. That's the argument going on towards the later claim.
So, I mean, I can see why I'd possibly help to have a jury. That one, honestly, I don't even know how much Ethan is going for in all of this. And I feel like they want a jury that just thinks, oh, it's really just some silly internet stuff. And really, we are looking at this from Denham's side because it's her answer. But who knows what Ethan has up his sleeve. I definitely have a feeling he will win. But yeah, that's all the slop I got for you today. So bye.